Scott Himsel graduated Wabash College in 1985. He majored in political science, minored in history, and participated in numerous campus activities. He graduated from law school at Northwestern University and is a partner at the Indianapolis Law Firm of Baker and Daniels. At Wabash, he serves as a pre-law advisor. He teaches a freshman tutorial and offers a constitutional law course each semester. With the chapel talk entitled Lies, Myths, or Harmless Falsehoods, Why We Can't Tell the Truth About the Supreme Court and the Not-So-Curious Case of Sonia Sotomayor, please welcome Professor Scott Himsel.
I think if you will think back to this past summer, perhaps one of the lines that you recall is this one: a wise Latina woman. You may remember that line because I think it was the remark that the media repeated most often this past summer. Sonia Sotomayor made that remark in a 2001 speech at the University of California at Berkeley, when she talked about her role as a federal judge and how she carries it out. In case you've forgotten, let me remind you of what she said, and I quote, "I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a white male who hasn't lived that life." Let me say it again. I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a white male who hasn't lived that life. Well, that wise Latina woman remark set off a firestorm when President Obama nominated Sotomayor to the U.S. Supreme Court. Rush Limbaugh called her a racist. Republican Senator Jeff Sessions disagreed. He said a judge is nothing more than an umpire who calls the balls and strikes. Senator Sessions said that a judge simply applies the law as written. So there is no occasion to draw upon one's experiences and backgrounds to decide a case, as Judge Sotomayor had asserted. Indeed, Senator Sessions said that letting your experiences and background influence your decision would not be fair or just. And then something very interesting happened. Judge Sotomayor changed her tune dramatically. Although she had said back in 2001 that she hoped a wise Latina woman would draw on her experience and therefore reach a wiser decision, in 2009 she changed her tune. Here's what she said to the Senate last summer, and I quote, "What I was talking about back in 2001 was the obligation of judges to examine what they are feeling as they're adjudicating a case and to ensure that's not influencing the outcome. Life experiences have to influence you. We are not robots. We have feelings. We have to recognize those feelings and put them aside. That's what my speech was saying." Huh? In 2001, Sotomayor said she hoped a wise Latina woman's experiences would cause her to make a better decision. But in 2009, she said she would put those experiences aside. Indeed, she went even further this summer in changing her tune. She embraced Senator Sessions' definition of a good judge. Like the senator, Sotomayor said there wasn't even an opportunity for her life experiences as a Latina woman to matter, because, she said, a judge's job is not to make the law, but only to apply the law as written. And it wasn't just Sotomayor who changed her tune. Her Democrat supporters repeatedly said that she would do no more than follow the law. So there you have it. Why did Sotomayor change her tune? And was her new tune, that one's background does not matter, a lie, a myth, or a harmless falsehood? Well, let me say, for starters, I don't believe for a minute that Judge Sotomayor was lying when she said that she would follow the law as a judge. Indeed, in most cases, Senator Sessions' analogy of judges to umpires works pretty well. Most Supreme Court cases are about complex federal laws. Even the names of these laws are complex. The Digital Millennium Copyright Act, the Employee Retirement Income Security Act of 1974. In cases like those, a judge is applying very detailed federal law and regulations like an umpire. The law itself gives the judge a great deal of guidance, and the subject of the law is such that the judge's personal background and experiences may not make much of a difference. But the umpire analogy is of limited value because the general public doesn't care much about the umpire cases. Rather, the public only cares about the 10 to 15% of the other cases out there, the ones that deal with hot-button issues, issues like abortion, affirmative action, prayer in school, and gay rights. It's harder to say that judges are merely umpires, that they merely follow the law as written in these kinds of cases. That's because the law does not tell judges much about how to call the balls and strikes in a case like that. The only thing the Constitution gives the judge is very broad and frankly ambiguous language. For example, the Constitution tells us we may not impose cruel and unusual punishment. Does that mean we cannot execute the offender of a very horrific murder because he was a juvenile when he committed the offense, or that he was mentally retarded at the time he committed the offense? The Constitution also says a state may not deny any citizen the equal protection of the law. What does that mean? Does that mean that gay Americans have the right to adopt children? And if they do, does it mean that they are entitled to the legal benefits and protections of marriage to protect those children in the case of death or divorce of the gay parents? And does equal protection require affirmative action for racial and ethnic groups who've been subject to discrimination in this nation? By the way, I don't know how to answer any of those questions. I have no easy answers for tough questions like that. But here's my point. Neither does the Constitution. The law provides very little guidance in the cases the public really cares about. And I think it is a myth to say that judges act merely as umpires, that they simply apply the law as written when the Constitution says so little about the issues that matter to us so much. Judges have to figure out some other place to turn when they decide these cases. So where would Justice Sotomayor turn? Back in 2001, she said that one place she would turn to would be her experiences as a wise old Latina woman. What did Sotomayor really mean when she said that? To find out, we need to follow a key rule of the liberal arts that neither the media nor the Senate followed last summer. We need to consider all of Justice Sotomayor's speech, not just one part of it, not just the wise Latina woman remark. And here is what Justice Sotomayor said to a group of female and Hispanic judges about these hot-button cases, abortion and such. And I quote, "There is no objective stance, but only a series of perspectives. No neutrality, no escape from choice in judging. Our experiences as women and people of color affect our decisions. The aspiration to impartiality is just that. It's an aspiration, because it denies the fact that we are, by our experiences, making different choices than others. We should not be so myopic as to believe that others of different experiences or backgrounds are incapable of understanding the values and needs of people from another group. However, to understand takes time and effort, something that not all people are willing to give. For others, their experiences limit their ability to understand the experience of others, and still others simply don't care." And here's the punchline. Personal experiences affect the facts that judges choose to see. Now, if you considered only the soundbite we heard over and over and over again this summer, it sounded like Sotomayor was saying that she will be a better judge than a white male because she is a Latina woman. But if you consider the fuller quotation, Sotomayor seems to be saying something very different. Not that she will be a better judge than a white male, but that she will bring a different perspective, a different set of experiences to the court than a white male who has not lived the same life experience that she has had. And I think she's also saying that in hot-button cases like abortion, there is no such thing as being objective. There is no such thing in abortion as simply calling the balls and strikes. Instead, there is only a series of perspectives, a series of ways to look at that difficult issue. And while some judges are capable of seeing tough issues from a point of view other than their own, that is not easy, and it does not always work. It does not always work because our personal experiences affect the facts we choose to see when we make decisions. We should pause for just a moment and test Sotomayor's theory. And I wonder, have there been times when you were arguing with a person who was unable to see the facts that you thought were important? Could that have been because the person you were speaking with had a different life experience, a different set of background, or perhaps dealing with a difference in race, religion, ethnic origin? And if that kind of thing happens in America today, should we include on the bench judges from all perspectives, including wise Latina women, so that all the facts are considered? Sorry, once again, my purpose today is not to answer the questions I'm asking. My purpose is not to answer these questions. My purpose is to express my extreme disappointment that no one even asked these questions this past summer. Not even Sotomayor, or her supporters, or the president. Instead, Sotomayor and her supporters just kept repeating, "She'll follow the law." And you can't blame her, because that's exactly what the last two Republican nominees did. Chief Justice Roberts and Justice Alito promised the Senate that they too would simply follow the law. That's why I title my speech, "The Not So Curious Case of Sonia Sotomayor," because they all three of them, expressed the belief in the myth of judging like an umpire. And since they all did it, is it possible that this umpire thinking is really just a harmless falsehood? After all three of them, Roberts, Alito, and Sotomayor were confirmed by the Senate. They won. And perhaps nobody was fooled in the end. Do you remember? Virtually every Republican voted against Sotomayor. But I don't think that the umpire myth is harmless. I think it is harmful. Once both sides embraced it, we were prevented from having a real debate about the meaning and place of diversity in America today. Rather than accusing Sotomayor of being a racist, as Rush Limbaugh did, or dodging the issue by relying on a myth, as everybody else did, that debate about diversity could have gone much deeper by addressing the questions Sotomayor raised back in 2001. To repeat, does our background, our experiences, our race, our heritage, our religion affect the facts that we choose to see when we make judgments, whether we realize it or not? And if so, do we need to ensure diversity on the bench and in other places? Now, these are important questions, and a Supreme Court nomination could provide an opportunity to go deeper, to take the issue seriously, to listen to all points of view and all perspectives. It provides a rare opportunity to educate the public that judging difficult cases on the bench, as in life in general, is a much more complicated matter than calling the balls and strikes. And I actually thought this deeper debate might happen last summer, because candidate Obama promised us a new politics, what he called a politics of hope. But hope requires understanding, understanding requires a deeper debate, and the Senate, the nominee, and the President decided to play dodgeball once more instead. Which brings me to my central question. Why can't we tell the truth about the Supreme Court? Why can't we tell the truth about the wrenching process the court has to go through to decide the tough cases about race, abortion, or gay rights? Perhaps we can't tell the truth about the court because our society finds it more palatable to play dodgeball with these tough issues than to wrestle with the tough issues and with our own imperfections, which those tough issues might bring to light. We've got to stop playing dodgeball if we truly desire a politics of hope rather than the old politics of fear. But there is a bit of good news. The good news for you gentlemen is that you are in an ideal position to learn how to wrestle with our imperfections. Because wrestling with human imperfection is what the liberal arts is all about, especially at Wabash. Let me be blunt. We don't play dodgeball here. Instead, we face the tough issues. And we're so small that when we face them, there's no place to hide. We also provide disciplines to study that make it impossible for us to do anything but wrestle with human imperfection. The agonies of leadership in classical literature and political science, the leader's angst as expressed by authors and playwrights in English and theater, the scientists' ethical dilemmas in the lab, and perhaps more than anything else, the great challenge of leading your peers in our fraternities and on our playing fields. President White has said that this college's goal should be to meet the needs of the country. Here you will find the tools to meet one such need, the need to think more deeply and wrestle more effectively with our imperfections. Now, I'm guessing that some of you may think that the very smallness that allows us to develop these skills also limits Wabash's ability to meet the needs of the country. I disagree. To some of you who are freshmen, the name of Bill Plaker, unfortunately, will be just a name. But to the rest of us who lived and studied and worked with him, he was a giant and in the embodiment of what this college seeks to attain. When I was a sophomore during our sesquicentennial, in 1982, here's what Dr. Plaker said about our smallness at Wabash. He said, "It takes only one lawyer in a small town to help the unpopular defendant get a fair trial. It takes only one doctor, one scientist, and a research team to raise awkward questions about human values. It takes only one business executive, one union leader, one social worker to bring imagination to bear and find a new way of solving a problem. Only one journalist or public official to expose the public's business to full scrutiny. Only one poet or artist to help us see the world all around us anew. It takes only a few truly educated people to make a difference." And here's one illustration. Years ago, after taking full advantage of all of the opportunities you still have as Wabash men, David Kendall graduated from Wabash College in 1966. Years later, working as a lawyer for the NAACP Legal Defense Fund, he wrestled with a very tough issue. Should we execute defendants who have raped their victims? You can argue that the answer should be yes. We should execute rapists. Rape is a horrible crime. It robs its victims of their privacy, their dignity, and their self-respect. But David Kendall wanted to provide an additional perspective, facts that others might not see. He presented the court with evidence that the death penalty was rarely used for the crime of rape, and when it was used, it was disproportionately imposed on black men accused of raping white women. The data, in fact, was so extreme and so clear that the Supreme Court ruled that the death penalty could not be imposed. They determined that the death penalty was being imposed not because a rape had occurred, but because the defendant was black and the victim was white. The court therefore ruled that while the state could impose severe penalties, including life without parole, the death penalty for the crime of rape was a cruel and unusual punishment prohibited by the Constitution. That wasn't easy. Given how much we all deplore the crime of rape, it took an act of courage for David Kendall to step forward and point out that the death penalty for rape was racist in its application. But by doing so, one Wabash man helped the Supreme Court have a deeper debate and wrestle with the tough issues of crime and race. This is just one example of how Wabash men have been thrusting themselves into the debate for over 175 years. There are many more. And someday, your time will come. Your time will come to step forward and to make a difference and to wrestle with tough issues. It may even happen before you graduate. So I invite you to seize this opportunity that Wabash offers, to learn how to wrestle with the tough issues, including, most importantly, our own imperfections. Because, as we learned from our unfortunate game of dodgeball with Justice Sotomayor last summer, our nation needs us.